thank everybody for participating and in this final panel of the day. Very important for us to have this panel with people from Japan, from Korea, to understand a little bit different models of competition law and different ways of to deal with digital markets. Thank you very much, Claudio, for moderating this panel. IBCI, thank you very much, all of you. So, Claudio, the word is yours. You can start. Thank you very much.
Thank you very much indeed, Vinicius, and I would say also Masako and Soojin for organizing this and for contributing to this panel. It indeed promises to be probably one of the most diverse panels, if we want, because even just the panel participants are from 3 different continents today, and I'm including in the panel participants, obviously, and because of the very timely topics that it will cover. And so even just for this reason, I'm really honored to be and moderate this panel. Now, according to the program, we will have 3 presentations. The first will be delivered by Soojin Nam, who is a professor, associate professor at Hankuk University of Foreign Studies and visiting scholar at USC Gould School of Law. And she will talk on regulation and competition in digital markets in Korea. The second speaker instead will be Masako Wakui, who is professor at Kyoto University and is the co-head of the Ascola Asia chapter, which co-organized this particular panel today. She will be talking about the role of competition law and authority in the process of digitalization, in particular in Japan. Obviously, she will be focusing on Japan. Last but not least, there will be Vinicius Klein, who is professor of law and economics at UFPR, and you all, I'm pretty sure that everybody knows you extremely well by now, so you don't need any further introduction. Who will offer final comments on these 2 presentations. It's worth perhaps reminding that the speakers will have roughly 20 minutes to present their papers. They will be showing some slides, and then we will follow up with a Q&A. Now, I don't want to add anything else because I believe that the time is short, the time is tight, and I prefer leaving the floor to our speakers. But I would say just one more thing. You said, Vinicius, that this was the last panel, and I would say that probably we've left, as often happens, the best for last. So, Soojin, sorry for being so informal. Soojin Nam, please, the floor is yours.
Well, thank you so much, Claudio, for such kind introduction. Let me just share my presentation. Can you see my PowerPoint shared on screen? Okay, great. So thank you, IBCI, Ascola, and the organizers for giving me this opportunity to speak about regulating competition digital markets in Korea. I really wish this was a physical, conference where I can be in Brazil, because I've never been, and I really want to go visit there once. So maybe next time we can all see each other in person. But for now, I'm still very happy to be here on Zoom. So what I'm going to talk about today is less of an academic paper where I have a thesis and an argument and other things, but I did want to provide kind of an overview of what has been going on in Korea in the recent years when it comes to regulating competition in digital markets. So it's going to be more informative than argumentative. I will provide some comments as well, but it's more going to be about explaining the recent developments in Korea. So with that said, I want to first talk about the background of Korean digital market. There are certain unique features in Korea, so I wanted to start off with that. And as is the case with many other jurisdictions, Korea's approach in regulating competition in digital markets is multi-pronged. So there have been efforts in the legislative branch where we wanted to amend laws or make new laws. And then we also had president-led, executive branch-led self-regulation efforts, which I think is kind of special. So I wanted to spend some time on that. And then, of course, we have traditional competition law and tools that have been, used to tackle issues that arise in digital markets. So that's roughly how I'm going to go about my presentation today. And to start off with the background of Korean digital market, well, our digital market has many successful domestic online platforms. So in a way, it's quite different from, let's say, jurisdictions like the European Union, where my understanding is that it's the so-called big tech, the American big techs who are dominant. In Korea, we have, our domestic online platform companies who are number one in major digital markets. Number one in search is Naver. Number one in instant messaging, online messaging is Kakao. Coupang is the Amazon of Korea. So we have our own domestic platforms who are doing really well. And they have plans to expand outside of Korea. Coupang is, for instance, is engaged in a lot of sort of outreach activities to expand their market share in other jurisdictions outside Korea, and other online platforms are doing the same. And so it's one of the places where Google is not number one in search. Naver is still number one. And I think this is, quite special compared to many other jurisdictions that we see. So this is quite unique in Korea, that we have our own, platform companies who are doing really well. So regulating these digital, online platforms were sometimes thought to impose duties on domestic players who are more prone to government pressure, and thought so regulating means you're kind of imposing additional burden on domestic players as opposed to foreign online platforms. So it was seen in a different light, certainly compared to Europe. And of course, the background is very different than a jurisdiction where a foreign online platform is the dominant one, and the political response to that is quite different. But in Korea, we again have a lot of domestic online platforms. And what's also interesting, and I think it's similar, but in other countries, but I think they have found ways to overcome the so-called who gets to be the lead on regulating competition of digital markets, because we have different institutions who are sort of interested and who have as their who are authorities to regulate digital markets. And in Korea, for instance, we have the KCC, the Communication Commission, the KFTC, that you will probably have all heard of, the Fair Trade Commission, which is the primary competition enforcement agency. We also have the Ministry of Science and ICT, and they are all sort of involved in regulating competition in digital markets. And so far, you know, this is a little bit off the record, but there have been some friction as to who's going to do what in this area. And there hasn't been a very effective resolution yet. So that's sort of another sort of piece of understanding the situation in Korea. With that said, I'm going to talk a little bit about the legislative efforts. So first of all, we don't have our own version of DMA. I think there was an effort to have our own version, but I'm going to talk about it in a few minutes, but that kind of stalled. So for now, we don't have our own version of DMA or let's say law that tackles online digital platforms in particular. What we have is we have amended our Telecommunications Business Act, short for TBA. This act, as you can tell from the name, is not our competition statute. It's not our competition law statute. It's a statute that actually sort of regulates telecommunications business. And this law is enforced not by the KFTC, but the KCC, the Communications Commission. And this law was amended. And it has been effective since, you know, a few years ago. And this law was the first sort of ever, is what the KCC prides itself in. It was the first ever to prohibit app stores from coercing their own payment systems on app developers. And so this was sort of, I do think it's the first. And so we have amended existing law to add this provision that prohibits this conduct. In the meantime, we also had many other bills. The main one I wanted to talk about today was the Fairness in Online Platform Intermediary Transactions Act. It's really long, so I'm going to call it the Online Platform Act. So I think initially, this bill was sort of our own version of the DMA. It was the one that was drafted and proposed by the Korea Fair Trade Commission. But during the negotiation, it had to, you know, go through many sort of rebirth, and at the end, the bill as it is now is a little bit anticlimactic. It now just simply requires issuance of written contracts by online platforms to its business users, and it introduces a new dispute resolution mechanism, but it's not, you know, if you compare it to the European DMA, it's really just, you know, just not a huge change from what we had before substantively. So the bill is stalled, and it's stalled, and I'm going to talk about this in my next slide, because Korea transitioned from feeling the pressure to have our own sort of system of new laws to tackle digital platforms to a system where we let the private sector lead self-regulation efforts. So that's what I'm going to talk about in my next slide. But here, I just wanted to say this bill was debated among the Korean competition community for a while, very intensely, but at this point it's just stalled. It's unsure whether it's going to pass ever, and there are many similar bills at the National Assembly right now. So as I alluded to before, we had a bit of sort of efforts to make new laws or amend existing laws, but then it changed in the beginning of 2022, when the administration changed from our previous administration to Yoon administration. So when Yoon administration took power, it was made clear that the administration preferred self-regulation. Now, I think this kind of leads back to the background that I talked about a few minutes ago about the particularities in Korea. There are lots of sort of our own domestic platforms that want to expand their business overseas. And there was a consensus within the administration that too much regulation on our own online platforms would be detrimental. And so they also, the administration is more sort of, they are pro deregulation in general. So they wanted to take a different path and say, okay, we're now going to institute a system of self-regulation by the online digital platforms. So what they did is they established a pan-governmental consultative body, and they established also a private self-regulation organization for the online platform market. And the latter establishment, the self-regulation organization, is a private organization, but with a lot of government involvement. And they have been divided into 4 different divisions, if you will. And I have it in the middle of my slide. The first division was an equal relationship. It's sort of the kabul relationship in Korea, meaning basically the relationship between online platforms and business users. Online platforms have, much more power, and the business users have less power. So they're where we call it kabul relationship. So there was division to discuss issues arising from that imbalance in power. And then another division on consumers, protection of consumers and users, another division focused on data and artificial intelligence, and another focused on ESG issues. So this went on for a while, and they actually published sort of their results earlier this year in May 2023. And they have basically committed to, I think, what remains in that online platform bill that I just talked about earlier. Because they said, okay, we are going to issue written contracts. In our contracts, we're going to include certain contractual terms with our business users to protect them. And they have also set up dispute resolution mechanisms. Some platforms openly committed to lowering the commission they're going to charge to the business users, and they have committed to providing transparency in their search algorithm by revising their user interface. And they've also made certain commitments to help grow with the small, medium-sized enterprises in this field. So I just have to say that how the Korean competition community reacts to the level and extent of the commitments is different for everyone, but it's certainly not nothing. They have voluntarily committed to these terms, and but it's worth asking whether they would have without all of the other things going on at the same time, like the bills that are sitting at the National Assembly. So that's where we are now. We had all these legislative efforts, but now we have turned to self-regulation. Although I should mention that recently the instant messaging service, our own instant messaging service called Kakao, it has 90% of market share in Korea. They faced an outage for a period of overnight, and it caused tremendous difficulties for many people in Korea to communicate with one another. And also the instant messenger has other ancillary services like delivery, reservations to restaurants, and all of that got messed up because of the outage. And so with that event, there was a public call for more heavy-handed governmental regulation of these online platforms. So I was sort of observing whether that was enough to change the Yoon administration's preference for self-regulation. So far, it hasn't. Although it got some attention, so far we're still in self-regulation world. So this is just a picture. I'm sorry, the it's not very clear, but it's just from the news. In the middle with the microphone is President Yoon, and it's saying, well, we're going to deregulate. We're going to focus on deregulating to stimulate the economy, investment, and to lift the burdens of the company. So that's sort of, as you can see, the general policy direction and orientation of the Yoon administration. Yeah, I haven't talked about competition law per se until this slide. But here I want to talk a little bit about what happened with our existing competition tools. So most notably, the Korea Fair Trade Commission published its guidelines on review of abuse of market dominance by online platform operators. And this is KFTC guidelines. It's not law. It's their internal guidelines that are published to let everyone know how they're going to review these types of cases. And this guideline defines online platform service that's subject to the guidelines, and adopt non-price factors to review competitive effects, as well as in market definition. When they assess substitutability, they're now going to not only look at price, they're going to look at quality, the amount of data provided, potential for innovation, etc. So they have made that clear. And they also have said something about how they're going to look at market definition when we face multi-sided platforms. They said, well, there's always this debate about, should we look at it as separate markets or as one market with the feedback loop, etc. The market definition, according to the KFTC, is that they're going to first look at the different sides as separate markets, unless there's evidence that points to combining the different markets together. So that's sort of their stance. They have made that clear. And then they also provided their assessment criteria for 4 specific types of conduct. And they are restrictions on multi-homing, MFN clauses, self-preferencing, and tying. And here, they're not saying that all of these are always anti-competitive. They, explain what these conducts are, what they're going to focus on looking, and they say, oh, well, but these elements may make such conduct pro-competitive. So it's kind of a balanced approach when they have made a list of potentially problematic conduct. They also recently, this is very recent, published guidelines on the self-management of dark patterns. Here, I also want you to notice self-management. It's a document that identifies 19 types of dark pattern that are classified under 4 major categories: defrauding, misleading, obstructive, and pressuring. And the KFT says, well, you should be aware that we are going to carefully review these type of dark patterns, some of which the KFTC says is already illegal under existing law. Some of them, we have to amend our existing laws to make them illegal. Some are maybe not always illegal. So they classify them in that category too, in the category of illegality. But they said, okay, well, here's something that we think is potentially an issue. So here are the types, you should be aware of them. And so that was published very recently. And we also amended our merger filing threshold to add a transaction value trigger. So, even if you have no revenues or assets, if the transaction value exceeds 600 billion Korean won, which is approximately 540 million USD, you need to report. And that is supposedly there to target, the so-called killer acquisitions by online platforms. So I thought it was worth mentioning that. In the remaining time, I don't have, let me see. Oh, I think am I over time yet? I have 2 minutes. Okay.
It's okay. If you can.
Okay. Yeah. Well, let me
a couple of minutes, 2 or 3 minutes is fine.
Okay, great. So I wanted to talk a little bit about the cases. So Kakao Mobility is a case that's very recent. The KFTC found Kakao Mobility, which is a company that provides taxi hailing service, to have violated our laws and abuse of market dominance. What Kakao Mobility did is it engaged in self-preferencing by manipulating their taxi hailing algorithm to favor Kakao's franchise taxis versus the non-franchise taxis. So their idea was, well, they have, a market dominant position in the taxi hailing service. They use that as a leverage to gain more market share in the taxi franchise market. By having the franchise taxis get better dispatch when customers call a cab. So they were fined approximately 25.7 billion Korean won, which is about 19 million, and it's under appeal. But this is where, they're putting into practice the guidelines that I just talked about abusive dominance of online platforms. They're putting into practice their starting cases, and this is one of them that happened recently. Another one that's very recent from this year, it's against Google. What happened in Korea is Google was accused of excluding a competing app store in Korea. It's called One Store, by providing various benefits to major game companies in Korea on the condition that they do not deal with One Store. So they only publish their games on Google Play and not in the competing, app store called One Store. And they provided lots of benefits to game stores for doing that. And so they were fined $42.1 billion. And it's one of the many cases at the KFTC against Google. Google had already been fined for restricting Android forks. So this is kind of a second sort of decision against Google. There's another ongoing investigation of tying YouTube Music with the premium subscription in the KFTC, according to media reports. Last but not least, this is sort of, I just wanted to quickly say that in Korea, we also had our sort of own version of Google Shopping case. It's called Naver Shopping. Naver, as I said, is our #1 search company. So it's similar in that Naver was accused of manipulating its algorithm to preference its own market service, open market service called Naver Smart Store, in its comparison shopping search results. So Naver is dominant in comparison shopping, and it used that market power to preference their smart store products. And so Naver was fined 26.2 billion Korean won. And this finding was affirmed by Seoul High Court. even though never appealed. So, as conclusion, efforts to regulate in Korea is heavily criticized by industry. The argument is made that these are domestic companies, and some report that domestic startups are leaving because of the regulatory environment, and the union administration has been very sympathetic to that argument. And I wanted to clarify something because the title of this session is such that the development of Korea's digital platforms and our domestic companies are not preceded by targeted competition policy. The competition policy really sort of followed the development, and the government's role in inducing, the digital development in Korea is debatable. There is no sort of strong evidence one way or the other. And I also want to say that there are clear political priorities in digital regulation in Korea. We're very much focused on protecting business users, the small and medium-sized companies, and and some consumers, but really the business users. And the policy generally has been driven by these priorities, less so sort of competition per se. So this is the end of my talk. I'm sorry I went over time.
Thank you very much, Mr. Soojin. It was extremely informative, and I took actually quite. I was taking notes all the time, so I have a bunch of observations, but I don't want to take time from Masako's presentation. Just one, since we don't have any question for now, then we will have, after Masako's presentation, we will have some time for a Q&A. But just a quick question about a doubt that I had since. A question actually that I had since the very beginning of almost the very beginning of your presentation. I was just wondering whether, do you believe that regulation, including industrial policy, or competition, or better the lack of competition, or better the lack of it, has acted as an entry barrier to global digital platforms, despite the fact that you have told us that what the government wants to achieve is deregulation? However, do you think that paradoxically, to some extent, the current regulatory landscape has also, in some ways, contributed to isolate Korea from the rest of the world when it comes to the expansion of these the big global digital platforms?
So that's a great question, and I think it's a bit of an empirical one. So I don't have an answer immediately for you, but anecdotally, you're right that in some cases, you're right that the regulatory environment that have existed maybe until recently. So before all the movement for deregulation sort of started, until recently, it was pretty, Korea is a heavily regulated state. And that it did cause problems with certain digital platforms expanding their service, namely Google Map. With, the requirement to have the server within Korea, that has made Google Map unusable in Korea. And of course, that have contributed to the success of Neighbor app, the domestic app. So you're right, there's definitely evidence of that too. But talking about Google or Apple or any of these other companies, so far, while they did have some of those hurdles, when it comes to abiding by regulation, as you know, there's a lot of informal pressures that come from the government, and it's generally thought that the foreign companies are less subject to those. And also the political pressures. So that's why I said in the beginning, there are some who make that a lot of regulation is going to be heavily burdensome for the Korean ones who need to answer to all of these pressures, while the foreign ones, they are very, confident in litigating against the government. They don't fear that as much as the Korean ones, etc. So there's a bit of both, I think. Yeah, but great question. Yeah.
Okay, fantastic. Thank you very much. Actually, after later on, if we have time, I have another couple of questions for you, and actually also recommendations on whether I can find the dark patterns study and
that person, the guidelines,
the guidelines translated. That would be really great. But I think we can, especially in connection with Masako's presentation, I think that we can continue our conversation after a presentation. Again, Soojin, thank you very much. This was a tremendous presentation. I learned a lot, I have to say. And before giving the floor to Masako Wakui, I would like to also say a big shout out to our first two speakers today, because they are joining us from Korea and Japan, where it's 4 a.m. in the morning, if I'm not mistaken. So it's I don't think it's easy to speak at a time. I was sorry for myself, but here is only 8:30, so it's nothing compared to that. So
well, I'm in LA, but it's really Masako who is
right.
Just
Okay.
Yeah, okay.
All right, thank you very sorry, I misunderstood. I thought you were in Korea as well, so you're in LA. All right, so since we mentioned Masako Wakui already presented your paper before, so without further ado, please, the floor is yours. Thank you. Whenever you want, you can unmute yourself, and we will keep.
Thank you for reminding us.
And the 20 minutes, just like before, will apply, and then
yes,
we can continue after you with some question and answer.
Let me check. Okay. Yes. Thank you very much for having us, having me. And if the Korea and Japan, if I choose, if I'm to choose one jurisdiction that, like, Japan can really do meaningful comparative law. For me, it's Korea. In fact, the most closest substantially, the competition law is very similar, but the dynamics is totally different, and I love that. and also, I do love the Soojin's explanation about the market structure as well. So my feeling is that we may be able to conduct a like natural experience or by doing this by comparing. But let me start with the Japanese situation. And so the core legislation that maintain a competition law is called Anti-Monopoly Act, which is regulated by the Japan Fair Trade Commission. But when it comes to the digital market, there isn't. This is another thing. So here, at least on the surface, we don't see that the some agencies trying to get like competitors mandate. Like they are not fighting. They are more like peaceful relationship under this headquarters for digital market competition law, or the competition, the cabinet of Japan. So, yeah, please you do this, because then I do this. That's the separation, division of the work, even overall. Then let me start with the JFTC. I think that these characterize the Japan's competition law enforcement. Let me explain these in relation to digital markets. So first, well, this is a kind of good way, or a kind way to describe that they're doing nothing or doing less or doing only little. Cautious, wholesome, fact-finding centric approaches. Soojin just showed us that these cases comes with lots of fine, but here is like minor or often none, no penalties. The emphasis on it. Oh yeah. So the of course, the digitalization is one of the focuses of the Japanese Competition Authority (JFTC's) activities. So if you click on this, you see this kind of list. Then so let me start with the case investigation, the real case investigation. So it may look many, but if you look at closer, you see like commitment. So basically, commitment procedure doesn't comes with a fines at all. Then closing the investigation. So they are all this. None of them are neither season digest order now fine or something like this. And particularly this closing the investigation, what does this mean is that closing investigation means that the JFTC launched the investigation, then the suspect decided to implement some measure, then JFTC find out, oh, it's sufficient. We're going to close it. Done. So this is it. And no fine and no commitment either. So even a simpler version of commitment decision. Then in relation to the merger, there may look many, but there are indeed a few instances where the JFTC approved the merger, given this parties would implement certain behavioral remedies, but to me it's like still behavioral, and that too is not that powerful, so it's not that much. Then the most recent case, like Microsoft and Activision Blizzard, UK CMA and US FTC are concerned that the gaming market may be like may become dominated by Microsoft, and excluding or almost like replacing the Nintendo and Sony. They are Japanese companies, but here JFTC just, oh, there's no problem. Please feel to go. So that's conclusion. Then so the other I would say like real cases. Then guidelines, well, yeah, some adjustment and some additions, but a lot of market studies, a lot. So market studies in Japan is like basically the fact-finding survey followed by the JFTC's position statement saying that if this is a case, there will be the violation. So it's more like the guidelines, but although it never says that there is indeed a violation. So it's like indicating that if you continue that, we may launch the investigation and there may be in fact a violation, but never. Well, yeah. So that's market studies, and then many study groups, and I was one or two of them. Then so they are more theoretical thing. So this is why I said JFTC's approach is like more cautious, not imposing any fine, not formal measure, and minor or none penalties. So very lenient, I think. But then, yeah, so there are, of course, pros and cons and the background. And the pros and the good thing is that they are very, very quick to fix things because there is no fine. They don't argue. The company goes like, okay, I will implement this measure. And then done. There is no appeal. So very quick fix. And JFTC is so proud that we are the first ever competition authority that fixed Apple case, like in a purchase, but well, then it's only about the gaming, not about the music, and there is no fine, and there is no guarantee to, but something like this. So very quick to fix things. Whether or not they are effective, questionable to me. And also there is risk of the under enforcement deterrence, and because they don't issue the full like fact finding when it comes to the commitment. Decision is very thin, like some few pages, and if they close the case, we know almost none, almost like 1, 2, 3 pages. So we do not know what's taking place. So it's puzzling because UK, actually, this is what we have. Like we do have this UTP and ASVP, abusive supervising position. So So if the JFTC thinks that, oh, this is overregulation, they can choose this. This differs from the Korean a little bit when it comes to fine, particular, but this particular UTP is different from the EU version of UTP. This is more like attempts to monopolize minor version of market anti-competitive effect or yeah. So then it's more like preventative nature. So they would feel okay to at least do this, but we don't see it. So it's like too risk averse, or because it's the foreign countries, or because of the US companies. As Soojin mentioned, and a little bit could be like informally putting some pressure. That's our doubt or concern. But if you look beyond the JFTC's own work, you may see a little bit more positive picture. Let me explain a little bit more. So JFTC may be lenient, but there is a bit of escalation mechanism here. So monitoring, follow-ups, and then escalation. So here in 2029, they are both market studies, and they issued a report about digital advertising. Then recently, 2023, focusing news content distribution was included in this first report, but recently, only last month, the FTC saying that we don't see the improvement. So we are now issuing a more focused report about news content distribution. So then further, here's a statement. Now we issue this report, and if there is no improvement, then we are going to launch the investigation. So that is at least that this chairperson of the JFTC said. Then here, another example is like they issued a report about online retail platforms, like online shopping, like Amazon. Then not the JFTC, it was taken by the legislator, parliaments, and it was almost a Korean version of current version of Fairness Act, like fair dealing, transparency. So they established so designated platforms are now subject to this act and obliged to make transparent and fair dealing. As Soojin, in the conclusion, Soojin said that it's more about protecting businesses here as well. Like it's more to do like the fair dealing with the business relationship. Here, there's some monitoring board. It's not private. It's rather us. I am actually one of them. And so we are watching. I sometimes feel that I have no idea what I'm watching. it's we have to watch everything, and that these terms and contracts are too large, and so yeah. But let me stop here. But at least this here there is an escalation mechanism or some the FTC issuing a report, but taken up by or prompts some governmental actions in a different area, different way. And we may see the similar. Again, this is particularly when it comes to App Store. Now they are subject to this act, but both are not effective. So we are now government now are talking about DMA-like legislation, and it may happen in fact. So yeah, so let's see. My concern here is that DMA in substance, but minus penalty. So yeah. But so this is the last example. The FTC issued the online restaurant review portal site. Then based on this, this JFTC's market study helped private party to sue the digital platform. Then they won the case and got damage. Like it was about unilateral change to the algorithm. So they demoted So ranking got worse. It was caused damage, and then at the court, this plaintiff cited the JFTC and also requested the opinion from the JFTC. The court did, and the JFTC gave the plaintiff the more favorable or helped them basically. So yeah, so this could be the dynamics that a little bit like make the competition regime more like altogether like wholesome. If you look at the whole picture, could be a more effective. Although I personally may want to see the find the Korea path. Yeah. So then again, okay, because of the theme is about the promoting the digitalization through competition, let me explain the Japanese market. So with this kind of, well, not entirely like doing nothing, they're happening something, but I think lenient, soft compared to the Soojin's presentation, Korea or EU, of course. And here as well, the emphasis tends to be self-regulation, co-regulation. so that's that. But I think that Japan has more. So then how is it helping compared to the being this light touch approach and leave the industry to regulate themselves? Is that indeed helping? So at least what we Japan do not have this like barrier issue. Amazon is still quite present, although there are also homegrown company. Rakuten is totally Japanese, Japan only thing, and Yahoo here is not the Yahoo rest in the rest of the world. Yahoo is owned by the Japanese company, so this is Japanese one. So they are there. Then when it comes to the messaging, like in Korea, Line is the dominant, like almost monopolist. Line is used to be started from the Korea, so that may be the reason of the success. But now it's owned by the Japanese company, and so there is no like WhatsApp comes like here 2%. Instagram is successful, but the Meta, we don't see that Meta that much in Japan. So yeah, this complicates like in Korea, these big companies do not want to see the regulation, and also the JFTC is careful. Like, if we JFTC, I think the JFTC has this feeling as well. Well, is this like whether or not the Rakuten sees something like private, like self-preferencing? Is this do they there should be violation where the Amazon is here? So that's the JFTC's feeling, where they, when it comes to the policy or more government or Ministry of Economy, okay, oh no. So they are, Rakuten and Yahoo Shopping is very influential at the government, at the core government. So they are very against the stringent regulation. Then what, yeah, but that makes that Japanese government is more cautious to address this. Unlike Europe, we don't see that the US only situation that you dominated by the US. We see this homegrown company, so that maybe at least one of the factors that the Japanese lenient approaches to them. Then question here is is that helpful, like to promote digitalization or innovation? Is that good for the whole Japanese market? Well, Japanese companies like Ryan, now it's Japanese company, and those may be successful, maybe doing well when it comes to the app to some extent. But what we don't see is that when it comes to the core of the digitalization, it's like everywhere else, like Google and Apple. And they are the one that's dominates the whole ecosystem. And so Yeah, digitalization, when it comes to this kind of digital competence ranking, that we might ask that how they measure, but look at them like Denmark comes first, okay. Sweden, Singapore, it's more like random. And USA, well, whether they are actively legislating actively or not, that's a question. Well, at least we see a lot of cases, but no legislation. Then Korea is here. So then where is Japan? You have to go farther here. You finally here. Like the Kazakhstan, for example, is not that big difference. So I like Soojin said, uh, it's I don't think that it's well, at least it's very difficult to say that find a causation between digital competition policy and digitalization, and then what we should do. I don't know. I have no answer. So that's my presentation. I'm sorry.
Thank you very much, Masako. This was, I already started thinking about your final questions. I think that these are dilemmas that we will have to face for a very long time, not probably forever. I don't think that you should blame yourself for not finding an answer to these questions, because these are probably the questions that drive our research, but at the same time, we perfectly know that we will never find a proper answer to them. A little bit like studying theology. Will you ever find an answer to the big question? Well, you gotta have faith in it. That's the only real answer. But I really also I don't want to repeat myself, but also here I managed to learn so much, and I have a bunch of questions. I would rather at this point, if it's okay for Vinicius, I would ask a couple of questions that you, and if Soojin wants to chip in and contribute as well, we yeah, because I don't see any other questions from the other participants. So if I have this privilege, I was thinking while you were talking that both of you have mentioned the DMA, obviously, and the European Union regulation. And I was thinking that at the inception of the DMA, there was a need for speed that, let's be honest, drove its creation. And that was mostly because the average case in Europe lasted a little over 3 years, except if we remove the outliers, the first Microsoft case, or that lasted a lot longer. Here I was thinking that it might be possible so that the Japanese and the Korean governments have little faith in competition law in digital markets, also because it seems to fail where it should succeed instead, which means catching up with the times fast enough, with the times that change faster than any governmental authorities can even think in terms or in procedural terms. So I was thinking, do you believe that, first of all, this is a problem that exists in your countries? And do you think that market studies could, at this point, serve as an ex-ante form of regulation? Or in particular, in the case of Japan, it seems to me that the authorities would require new enforcement powers to use market studies in that way. But I might be wrong.
Oh, well, thank you very much for your question. Well, digital market study, the government, well, administrative branch or some ministry, or can have power without market study, but uh, but they want to have some evidence or justification to have the regulation, and that market studies tends to be used for that. Then, when it comes to the speed, I well, I think that I remember that Korea had a discussion that Korea under the competition law, there are many tools to use. So probably, that's you or Yong? I'm sorry. I don't remember. Yeah, I heard as Korea questioning that we need further power when they have the lot of tools under the competition law already. Like in Japan at least, we have this kind of argument. We have this very preventative UTP regulation, which doesn't require the establishing market power. Even they don't delineate the market like very rigorously. So probably we can, the FTC could be quick to intervene. So there should be no speed issue, but the thing, peculiarity, unique feature of the JFTC is that they don't do. So unless it's really clear this is wrong, this is always violation, no justification whatsoever. Well, or little justification. Otherwise, they may lose. They may. So my feeling is that we have to oblige the competition authority to act upon that case. Otherwise, they won't do it. So that's the issue, I think. To my very personal comment. You. Did I answer to your question? I don't know.
Absolutely. Thanks very much indeed. And that makes me think, that sometimes the law in the books is probably not what it could be. I mean, has potential, but it's different from the law in action. Because if you tell me that actually there wouldn't be any hindrance to the JFTC to act more swiftly and at the same time also more powerfully, then it means that probably there is a problem just with the law in action rather than with the law in the books. So yeah, thanks very much. Before I read though the question that comes from the audience, Soojin, did you want to add anything on the Korean side on this point?
Yeah, no, thank you for your comment / question about sort of speed. The issue of speed, that it takes just too long to carry on the existing competition cases. So you needed sort of the so-called ex ante, although that wording is very controversial now. But anyway, ex ante regulation like DMA. And I think that was in Korea also an argument that supported our efforts towards having our own sort of online platform act. But what happened in Korea was to get that act passed took a really, really long time and still sort of going. So what's impressive in Europe is you got that political will and pressure to push forward. And, I have to say, and I know that a lot of Europeans deny that it has anything to do with the fact that it's all American companies. But, I cannot help wonder if that has a little bit of something to do with that. In Korea, that legislative sort of, discussion, negotiation, that actually probably took way longer than it really should. And so I think the self-regulatory approach where we kind of bypass that hurdle at the National Assembly was the Yoon government's way of sort of tackling that speed problem. But you're right, the speed, the market, once it happens, it tips, and I think there is definitely some truth to that in certain markets. So that was sort of our experience. We just couldn't get the law passed. Yeah.
Okay, really interesting. Actually, what I was you made me think is true that there must be even unconsciously a general consensus that at least there was, that the DMA was at least something that we should have considered, because we don't have really skin in the game when it comes to enforcing the DMA. But a thing that very few people consider is that most of the lobbying is also American lobbying. for this type of regulation, just like the complainants in cases, competition law cases that targets American digital platforms are generally speaking American themselves, like the Qualcomm, AMD, and so on and so forth. The Microsoft case as well. So yeah, the Americans are in a way or another anyway playing a role in in these European regulations. It's true, but in both ways. We have if we have a couple of minutes, what do you think, Vinicius? I would read this question for Soojin now. Is that okay for you? Okay, perfect. So we have a question for you, Soojin, which comes from Neha Vias. I'm sorry if I mispronounce your name. And it says, have there been any efforts to regulate dark patterns with regard to PIPC and consumer protection in Korea, for example, like that in California Consumer Privacy Act?
Okay. Thank you, Neha, for your question. Definitely. So I only talked about the KFTC's guideline, but the Personal Information Protection Commission in Korea is also active in its interest in regulating dark patterns. As far as I know, they have made it a priority in their 2023 sort of yearly plan. So they are sort of preemptively investigating various types of dark patterns in, online service providers right now. I don't think there's any sort of particular action that is worth noting at this point, but they are definitely looking at it too. And you said also, consumer protection. And I think I should clarify that the dark pattern regulation from the KFTC, it's, I think, more primarily geared towards consumer protection than competition per se, as we understand it, because they're concerned about protecting consumers. So KFTC has multiple roles. They are the competition enforcement agency, the so-called antitrust law, but they also are in charge of Korea's consumer protection laws. So they have published these guidelines that I think are sort of both consumer protection and a little bit of competition too. So yeah, there are multiple agencies again here for looking at the same thing. So we will see how they can sort of manage and divvy up their work.
Okay, thanks very much. Then we don't have further questions, I believe, and in general, anyway, I think it's better if now we leave the floor to Vinicius. I would like to ask you, Vinicius, to offer your comments, but also if you have further questions for our two speakers, and you can freestyle with the rest of the time that we've got for this panel. Thank you very much.
Thank you, Claudio. Thank you, Soojin. Masako was excellent presentations, very informative for me too. I learned it a lot. And when I was thinking about the panel, I was thinking maybe people need to know more about the Asian and Korean experience because they have different experience and different features. And maybe it's hard to say that these different features have a significant role in more digitalization or more tech companies, but anyway, it's important to see this kind of different roads, not just the DMA and United States, and like maybe European is going to, because we always talk about the exception on U.S. Antitrust law was the first one, but it has a significant role of the courts, not the same as the rest of the world. And maybe the DMA is exceptional era of European Union doing different things from the rest of the world also. But one thing that got a lot of my attention is this focus on co-regulation and self-regulation, because I don't think in Brazil the discussions are going in this direction. The discussions usually are we should have a Brazilian DMA with a lot of ex-ante prohibitions and charge it in some regulatory agency or maybe in the competition authority. This is the biggest discussion now in the Congress of Brazil. If we're going to have this power to regulate or to do like a mix of regulation and competition law in the competition authority or in the telecom agency, and we're going to have this kind of work together. The telecom agency will do some regulation on the patterns of companies, and competition authority will do the analysis of anti-competitive effects. And we don't discuss so much the idea of self-regulation and co-regulation in Brazil, I think. And another thing that Claudio pointed out was, I think, very, very nice and very smart, like the need for speed. Because in Brazil, I think we have, of course, these cases to take a lot of time. But when I see the public opinion, the focus is not on the size of Amazon, at least in Brazil. Usually the focus, the urgent matters are of other kind of regulations of digital markets. Consumer regulation, fake news, and freedom of expression regulation. Not the. So I don't see this in the literature. There is this need for speed because things are gonna happen, but maybe it's because all the companies are not Brazilian. Most of the companies are not Brazilian. I don't see this pressing too much, and maybe have this idea that Brazil will not be able to change the international landscape because it doesn't have the power to do that. But even though we have this, we don't focus too much on this idea of self-regulation and co-regulation. And we don't have this tool of market studies in Brazil. Like in Brazil, the competition authority can do a study, do like economic studies, but doesn't have these tools that say that if you do a market study, and even though you don't find any illicit conduct, you can impose remedies or impose a change of the market structure or change of the business model of the companies. So these studies are usually made for informing the competition authority on specific cases or on doing ex post evaluation of a past decision, things like that. And then this idea of gradual enforcement that Masako pointed out was also very interesting. This idea of doing a market study, then after doing more things. But in the level of enforcement in Brazil, I think you don't have a very big level of enforcement. We have some cases, but there is no big enforcement in Brazil also. And the discussions in the Congress are a little don't have so much speed. It's hard to pass. I agree with Soojin. It's amazing how this thing worked very quickly in European Union. So my question or comment would be like, do you believe in this self-regulation, co-regulation approach can work in practice, or is going to be a way to capture and to undermine the enforcement of competition law? Masako, that's already pointed out.
No, it doesn't. It's a whitewash. And for me, it's like they ask the mafia or yakuza, if you know them, like to regulate themselves. It's nothing. So better not. Soojin, what do you think?
What do you think?
Yeah, I think in general, I do agree with you, Masako, that you cannot, let the yakuza regulate themselves and behave peacefully do not, do anything bad. When it comes to certain types of conduct that could have been regulated by a government entity, and you sort of have the companies regulate themselves. For certain type of conduct, I think it might be more successful than others. And once you can sort of and usually those are the easy ones to get them to do, I think. When it's really going against their core interest or business operations, of course, it's going to be very difficult. In terms of Korea, as I said, the Online Platform Act, what remains of the bill is not much. It's something that the companies can do. Okay, we're gonna now give you advance notice before termination. We're gonna give you written contract, all etc. Those things, because we couldn't even get that law passed. The self-regulatory approach, had the company say, look, if you don't do this, there's going to be consequences. You might get something even more harsh. And so you can kind of get them to cooperate and give in a little, have them make a standard that could, better the industry as a whole. So I think for things like that in this context, it worked a little bit, but for really core sort of antitrust / competition behaviors, I think self-regulation or co-regulation definitely has limits. Ideally, theoretically, if it works, it's wonderful, right? But the reality is much darker, it seems. Yeah.
Totally.
Thank you.
Totally. Yeah. Yes. Well, the area that works here, like the customer service. What dispute resolution? They resolve the dispute quicker in relation, and so they are made their customers happy. They would do it anyway. Never bundling, never like kicking out the startup company. They never deal with those things under the self-regulation or co-regulation.
Claudio, can I do a final comment? Then I pass to you.
Absolutely. Please go ahead. Yeah.
Like another thing, because usually we talk about competition law and consumers, and you said a little bit about business users. And I think there is a difference, like the way you do the enforcement, if you think about the business users and traditional consumers. And what do you think this is the main difference?
Soojin, would you like to go first? Well,
sorry, so you said business. Can you repeat your question?
Yes. Like you said that you have a focus on business users, not just final consumers.
Yeah. So I think at least looking at the experience in Korea, a lot of the political pressure came from the business users of various platforms. So these would be, for instance, if it's a food delivery app, the restaurateurs. If it's Coupang or like the Amazon of Korea, it would be the sellers. And so it would be them who is, who's much better organized than the consumers in terms of pushing forward a certain policy goal and having it related to, the various power players in our society. And so naturally, a lot of discussions have focused on protecting those business users of various online platforms, and of course, consumers do come in. But I, in my personal opinion, like the business user focus is bigger.
Well, yeah. Well, my perspective before digital this big tech, I tend to think that we shouldn't protect. I didn't want to protect businesses that much. Well, here at the ASBP, obviously supervising position, it's about B2B. Tends to be majority, most of them, and I didn't like it that much, but nowadays, like these business users, they doing the business and they're big like Google ecosystem, either Amazon, and there are differences between these businesses and the consumers become less, I think. So both needs a well, in my view, maybe wrong, but yeah. So
Thank you, thank you. So, Claudio, if you wanna do like one more or one,
Sorry, Vinicius, I couldn't hear your question.
sorry. No, I'm okay. Thank you very much. If you wanna do one final question or one final round, or you wanna,
I don't want to take too much of the time of our invited speakers, and I though would like to see. I don't know if we have received another question because I
no.
see it. Okay, so it's just the old one that wasn't erased from the count. Okay, perfect. So I have a bunch of questions, and I would say I will use my privilege as moderator of this panel to send to both the speakers emails privately and ask questions so that I can bother them also after this session. You won't get rid of me, but I really like the that sounds not so bad. But I really like probably these final thoughts that we have reflected upon in these last few exchanges, that probably co-regulating in these industries is a little bit like, I don't know, like leaving the wolves in charge of the hen house. So you don't want to really do that. You want to have a good dog that you can really trust. You don't really want to have a bunch of wolves doing that job. And with that thought, again, thank you very much to our invited speakers, Soojin, Masako Wakui, and Vinicius Klein, for this amazing exchange of ideas, I would say. We have, if not learned, at least I learned a lot. But if anyone knew already everything, at least this has been lots of food for thoughts for ruminating in the next few days on and coming up with new ideas for research and policymaking. So thank you very much, and thanks also for inviting me.
Thank you very much for every one of you, Masako, 4am, Soojin, Claudio, thank you very much. PCIs, thank you three for all the efforts.
See you
Thank you.
then. Bye
See
bye.
you. Bye.
Thank
Bye.
you. Bye, everybody.
Bye.